All right. We're here, I believe, on a pretrial on Chloe Ireland. I understand there is a mediation agreement. At any rate, counsel, how would you like to proceed at this point?
Judge, we did have a mediation regarding the father, Mr. Cody Ireland. It was a temporary agreement. I did present this to the department, and we did discuss it. And Judge, we're going to have to proceed to some type of a trial in this matter. While there are some points of agreement, I don't think it meets a preponderance of evidence for the statutory grounds. And because of that, I can't, I don't want to try to do a plea on it and find out that it doesn't meet muster later on.
So basically, you're requesting a jurisdictional trial, and that would be as to both parents?
Unless, Mr. Delaney, maybe some more discussion would be appropriate, maybe a further mediation. I mean, we do have some points of agreement. I just think we're going to need some more, and we don't have that right now. It's close, but I don't think it's quite enough right now.
All right. Well, if there's not a plea that's available, and a plea basically can only be entered if we have an agreement with everybody, but any comments from the attorneys representing the parents?
Your Honor, I represent Ms. Ireland. I believe we had a fairly successful mediation, so I don't know if we're ready for a plea or if Mr. Sommerfeld was including her with the father, that there are just not enough points there. So I guess I would have to inquire further.
Judge, I was only referring to Mr. Ireland, Cody Ireland. I thought we were taking that part of the case first. We do have an agreement regarding Kendall Ireland, the mother, and that was a successful mediation, and we are ready to plea if that's what they want to proceed to today.
All right, so we'll get to that in just a minute, but as to the father, Mr. Delaney, and I guess if there's no agreement that there's a plea, there isn't a plea, even if someone thinks there is, so we'll need to set the matter for trial.
That's correct.
All right, and Mr. Delaney, would you be requesting a jury trial?
Well, I hadn't discussed that with my client because he did sign, all the parties signed a mediation agreement, but we don't have an agreement. So my only question for my client is perhaps a breakout room, whether he wants a jury trial or a bench trial.
Well, I'm probably just going to go ahead and set a jury trial. If it changes, I'll certainly have a pretrial in advance of that, but we'll get a jury trial date. Mr. Sommerfeld, assuming that it's just for Mr. Ireland, how long do you believe a jury trial will take? 1 day be sufficient?
Yes, Judge, 1 day.
All right, yes. So we'll schedule that, and for a Tuesday, a week and a half in advance or so, we'll set basically a final pretrial. In the event that there was a resolution, wonderful. If there isn't, the trial is fine as well. Mr. Ireland, do you have any questions?
No.
Okay, all right. And then as to Kendall Ireland, you believe we're in a situation for a plea, counsel?
Yes, Judge.
All right.
Does the court have a copy of the mediation agreement?
I do. Is it broken down between the parents?
Yes.
Yes, it is. There are two of them.
Okay. All right. I do have, yes, this is Kendall Ireland's matter. So, Ms. Ireland, do you understand that there's an agreement to resolve this case, at least the jurisdictional part? Do you wish to go ahead with that?
Yes, I do. I also need a copy of that because when I got sent a copy in the mail, it wasn't my actual mediation agreement. It was Cody's.
All right. Do you want to go ahead with the hearing today, or do you want to put it off when you've had a chance to review that
No, I
again?
agree with the mediation. I just
Okay.
needed a copy of it for my personal record.
All right, can you send her a copy then? We'll send you a copy. We may already have, but that's certainly no problem to go ahead with it. All right, and the guardian ad litem, is that you, Mr. Gila? Or is it Mr. Leonardson?
It's me, Judge.
All right, are you in agreement with this as well?
Yes, I am.
All right. Just a second here. All right, well, Ms. Ireland, I have some questions for you before we can actually take the plea, but first I need you to raise your right hand if you would. You solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right, you can put your hand down. If you could state your name for the record, please.
Kendall Helen Renee, Ireland.
And are you the mother of Chloe and Liliana Ireland?
Yes.
You understand that there's been a petition involving those two children that has been filed with the court and is in fact before the court and the subject of this hearing.
Yes.
Okay, and this is a child protective proceedings. I've been advised that there is an agreement. Do you agree that you in fact you and your attorney have reached an agreement with Department of Health and Human Services?
Yes, Your Honor, I do.
All right. Now, there was a petition that was filed. If you wanted me to, I would read that petition to you. Do you want me to reread it to you?
No, Your Honor, I have a digital copy.
Okay. And have you read it?
Yes, Your Honor.
And do you believe you understand it?
Yes, Your Honor.
And you have an attorney representing you on this matter, Mr. Brown, correct?
Yes, Your Honor.
Have you discussed this matter with him in sufficient detail that you feel comfortable going ahead?
Yes, Your Honor.
And do you understand if I accept the plea that you've indicated you're about to give, you would be giving up your right to have this matter, the jurisdiction, whether the court would have jurisdiction in this matter, you're giving up your right to a trial on that issue by a judge or a trial by jury?
Yes, Your Honor.
And that you'd be giving up your right to have the petitioner, Department of Health and Human Services, prove the allegations in the petition by preponderance of the evidence?
Yes, Your Honor.
And you also understand you'd be giving up your right to have witnesses against you appear and testify under oath at trial, to have you or your attorney cross-examine those witnesses, and to have the court order any of your own witnesses to be present?
Yes, Your Honor.
You understand that if you go ahead with the plea, one of the consequences could be that the plea later could be used as evidence in a proceedings to terminate your parental rights in this matter. Do you understand that's always a possibility?
Yes, Your Honor.
All right. And you understand that if parental rights were for any reason subsequently terminated, your obligation to support your children would continue until a court of competent jurisdiction modifies or terminates that obligation, an order of adoption was entered, or your children were emancipated by law. Do you understand that?
Yes, Your Honor.
All right. And are you familiar with the mediation agreement?
Yes, Your Honor.
All right. Let me just take a...
Judge, I would ask that we attach and incorporate by reference the mediation agreement. Was dated September 11th of 2024.
I will do that.
Ireland.
Right. I will do that, but I'm going to have Mr. Brown go through it on the record with his client, if you wouldn't mind doing that, Mr. Brown.
No, that is fine. Ms. Ireland, can you hear me okay?
Yes, I can hear you.
And do you recall the mediation we had back on September 11th?
Yes.
I'm going to go through a few things with you. I just want you to say if you agree with them, if they are true, or if you disagree, okay? So here is the first thing. Kendall Ireland acknowledges that the condition of the home, specifically the carpet, was unsuitable for the children, noting black mold. She shared that they had a puppy and they were trying to housebreak the dog, but there were issues with dog feces in the home. You also noted that the dog would jump on Chloe, knocking her down, and also that the excessive clutter was potentially harmful to the children. Do you agree with that?
Yes.
You also note that your mental and physical health concerns interfered with your care of the children, as you did not have adequate support You were overwhelmed and unable to care adequately for the children, noting supports were needed regularly to help you care for the children. Do you agree with that?
Yes.
You also shared that your relationship with your husband is unhealthy and toxic, and that you are a victim of domestic violence. Additionally, Cody's relationship with the children puts the children at a substantial risk of harm. You note that your husband, Cody, was physically aggressive with your daughter, Chloe. You note that Cody Ireland was referred to anger management classes but did not participate as referrals were not received. Do you agree with that?
Yes.
At the time this petition was filed, do you agree that the children did not have a safe place? Or let me rephrase that you did not have a safe place for yourself and the children?
Yes.
Do you acknowledge that there was a firearm located in the home? Perhaps it was not accessible to the children, but there was a firearm in the home.
The verbiage on the actual mediation agreement is what I agree to. It says that I acknowledge that there was a firearm, but it was not accessible to the children.
Yes. Would you agree with that?
Yes.
While at work, you acknowledge that Liliana was left in Mr. Ireland's care and maintenance, and he confirmed he was able to care for the child when he actually was not.
Yes.
And you also finally acknowledge that you left your husband, Mr. Ireland, 3 times, but returned each time due to the unavailability of housing options, and also returned with the children to an unhealthy and unstable environment and relationship.
Yes.
I would defer to Mr. Sommerfeld if he has anything to add, Your Honor, but I believe that would be factually sufficient.
Mr. Sommerfeld, any questions on the mediation agreement of Ms. Ireland?
Just something briefly. Miss Ireland, can you hear me okay?
Yes, I can.
And you would acknowledge that Chloe Ireland is under 18 years old?
Yes.
And also that Liliana is under 18 years old?
Yes.
And how old are the children respectively? About a newborn and about 3 years old, 4 years old?
Liliana is almost 6 months old, and Chloe is 3 years old, almost 3.5.
All right. Thank you. I have nothing further, Judge.
Mr. Gilo, any questions?
No, satisfied.
Mr. Brown, do you believe that there is a sufficient factual basis for the court to assume jurisdiction over the children through Ms. Ireland?
I do, Your Honor.
And Mr. Sommerfeld, do you as well?
Yes, I do, Judge.
And Mr. Gilo, do you as well?
I do.
All right, as does the court. The court finds that the admissions by Ms. Ireland were freely and voluntarily, knowingly and understandingly made. And the court will assume jurisdiction over the children through Ms. Ireland. We'll schedule this matter for a dispositional hearing. Ms. Ireland, you do have certain rights that attach at this point. You have the right to appellate review to challenge any errors you believe may have been made in this process, which is called the adjudicatory process. Any of those that could be challenged in an appeal from the court's initial order of disposition. And I will go through these rights again after
Your
disposition.
I do have a family relative that worked in foster care in Gaylord, Michigan. Is it okay if I just waive everything and try to go straight to adjudication?
Well, that's what we just did, was adjudication. The
Okay.
next thing will be disposition. My guess is, and I have a couple more questions to ask you, but my guess is that things have already started on your parent agency treatment plan, even though we don't have an official one yet. In other words, that you're doing some of those things. Is that correct?
As far as I'm aware, I did sign the parent agreement plan with Wells.
Sure.
I'm waiting to get Kim Strauss to do my referral for the psychologist review.
Right.
I am doing parenting classes as well as therapy.
Okay, well, it sounds like the case is on the right track, and these are things that are happening. These are simply rights that I'm required to go through with you. And I don't want you to waive them without at least discussing it with your attorney, Mr. Brown. We will be scheduling a dispositional hearing down the road. But once again, I saw Ms. Hughes nodding her head that it sounds like you're already doing what you're required to do. Ms. Hughes, did you want to say something?
When you're done with the adjudication process, we did want to just bring up the current order as regarding parenting time in light of some things that have transpired in the case.
All right, I'll get to that in just a minute. So, ma'am, if you chose to file any appeal and you're indigent that is unable to pay for an attorney and or paperwork, you'd be entitled to the appointment of one at the county's expense, and also to the transcript and any other documents that the court had without charge. And if you do not, if you choose not to challenge the assumption of jurisdiction in an appeal, well, let me phrase that differently. You should also understand that you may be barred from challenging the assumption of jurisdiction in an appeal from an order terminating parental rights if you do not timely file and appeal the initial dispositional order. Once again, we're not there at the initial dispositional order yet. We will get there soon, but I just wanted you to be aware of those rights. I will also attach a mediation agreement to the jurisdictional order that the court will be preparing. That will, of course, be the mediation agreement signed by Ms. Ireland. So, Ms. Hughes, what was the issue you were referencing?
So we just wanted to, right now, the current order for parenting time is 3 visits per week for 2 hours apiece. Miss Ireland has recently had some pretty significant medical issues that have come up that will likely result in her being in the Grand Rapids area quite regularly, maybe even for lengthy periods of time for treatment that she might be needing. As well as Chloe Ireland has recently started school, so she is attending school full-time Monday through Thursday. And Dad is currently working 7 days a week, 12 hours a day. So the department would just like to propose to the courts that we adjust those parenting times to 2 parenting times for 3 hours, which would still allow them the same amount of time with the children and possibly a couple of days of virtual video phone calls with the children.
So that would be 2 3-hour parenting time each for each parent?
Correct.
All right. Mr. Brown, is that agreeable?
I guess I was unaware of that, so I would have to defer to Kendall. I see she has her hands raised.
Ma'am?
Your Honor, I have recently found out that I have 4 masses.
Okay, Kendall. Is this something you really want to put on the record right now?
It's fine. I understand. It would help the situation a little bit better in case later down the road I'm not able to do the order of parenting time as follows.
All right.
I have 4 masses that have to be biopsied, 3 in my breast, 1 in my lung. So it's going to be hard as it is to do the 3 visits. It might even become hard to do the 2 visits. So, I do think that at least for me, it's going to be easier as of right now to do the 2 3-hour visits and a couple virtuals, just so that way, if I'm not able to make it to parenting time due to the illness or biopsies or treatments or anything else that I have going on, that I could do the virtual visit as an alternative.
All right, ma'am, do you believe that you and Ms. Hughes could work out parenting time?
Yes.
And I think, at least as to you, just to make it discretionary, there's some moving parts, and Ms. Hughes is obviously aware of the situation you just described. So unless there's an objection from counsel or from the parties, I would just indicate that as to Ms. Ireland's parenting time with the children, it would be discretionary with DHHS, with the understanding it would be approximately the same or more ultimate time-wise per week that is going on, taking into account Ms. Ireland's situation. All right, Ms. Ireland, I am sorry to hear a bit of that, but I wish you the best in your diagnosis. It's a hard, stressful time, I know.
Yeah.
All right. I guess, is there anything else we can do on Ms. Ireland's file at this point?
Judge, I would ask the court to state on the record the statutory grounds, the MCL 712A.2B1 and 2. The department asserts that based upon the mediation agreement and what Ms. Ireland agreed to, that both of those statutory grounds would apply at the level of preponderance of the evidence.
All right, and thank you. I did forget or omit that part. The court does find by a preponderance of the evidence based on the admissions of Ms. Ireland just put on the record that MCL 712A2B1 and 712A2B2 have been met once again by a preponderance of the evidence, and it is appropriate for the court to assume jurisdiction over them. All right.
I agree to the plea and have court take jurisdiction because I am not familiar with either of those two.
Right, and those are basically the same things we went through, and
okay.
That's just the catch-all phrase that it comes under. That doesn't add or decrease to you or from your rights at this point.
Okay.
All right, I think it is a lengthy process. I understand it, but I think we've done what we can on this. As to Mr. Ireland's case, then that matter will simply be set for a jury trial with a status conference sometime before. It'll be a one-day jury trial. And is there anything else we can do in his matter?
No, thank you.
All right.
No, Your Honor.
As to, I'm assuming, well, not just a jury trial, it'll have to be in person, not by Zoom, obviously. Okay. Ms. Ireland, you are invited to that. You'll get notice of it. Unless you're being subpoenaed as a witness, you don't have to appear. Your attorney will not be at that hearing. But you have the right to be there. If you decided you could not be there, perhaps because of health or otherwise, but wanted to observe it, if you just let the court know, we could make sure that you could be available by Zoom. Usually, we don't have a Zoom hearing available if we're doing it live, but in your case, we'd make an exception. Okay.
Am I able to actually be used against Cody? We are legally married.
Well, that's something you need to discuss with your attorney.
Okay.
All right. Thank you.
Mr. Brown,
The Ireland matter is adjourned.